Okay, so hello everybody and welcome to our webinar. This is Simone Obermeyer and I'm responsible for the Small Business Lending Department at Community Capital. For those of you who are not familiar with us, we are a small nonprofit small business lender who provides loans to startup and existing businesses in the Hudson Valley, as well as in the borough of the Bronx and in Fairfield County. Our typical loans are SBA microloans up to $50,000, and we generally work with businesses who are not quite bankable yet, maybe because they're too new, maybe they have some credit issues, and maybe limited collateral. So if you're interested to speak with us further, just feel free to reach out to me directly after the webinar. As a small business lender in this region, we strive to not only provide financing and funds, but also technical assistance and training to our small business borrowers. And so I'd like to extend a warm welcome to all of you, and thank you for joining us today. As a nonprofit, we rely on outside funders and grants to be able to provide quality training opportunities and support to our small business clients. Today's webinar is in part brought to you through funding from the Small Business Administration. We truly appreciate their support. Thanks to the SBA for being a partner to small businesses. Today's topic is avoid the 10 most common legal mistakes that can ruin your small business. We'll cover a range of issues that might come up as you open and run your small business, and we'll provide pointers explaining how to avoid common pitfalls. We will also do our best to make the presentation interesting and easy to understand. And to do that, I'm happy to have a true expert with us today who will lead us through the presentation. William Malpica is a seasoned business attorney with over 15 years of experience as a trusted advisor to corporations, financial institutions, and other business interests in New York and Connecticut. He has worked as an attorney in private practice, as well as a member of in-house general counsel departments, and has advised on a great variety of transactions, totaling well in excess of $1 billion. So not so much a microloan. Will is committed to improving communities through his service as a volunteer to important nonprofit organizations. For almost a decade since its formation, he has served as pro bono counsel to Building One Community, a nonprofit in Stamford, Connecticut, dedicated to the healthy integration of newly arrived immigrants. In recognition of his service on behalf of B1C, he was named 2016 Connecticut Volunteer of the Year award by the Pro Bono Partnership, an organization that matches attorney volunteers with nonprofits in the tri-state area. Will also volunteers with Community Capital and is a member of the Executive Committee of the Board of Directors of Latino Justice PRLDEF, the National Civil Rights Organization. Will is a graduate of the State University of New York at Albany and the Fordham University School of Law. He's a native of Brooklyn, New York, and currently resides in Westchester. I'm very grateful that Will has agreed to present today's webinars and to share his wealth of expertise with us. So thank you and welcome, Will. Before we get started, let me just take a quick minute to walk you through the technology. I hope everybody can hear me by now. Like I said, we'll try and speak up. If you do have issues with your audio, there are generally two options. You can either use your computer's microphone and speakers, or you can use a telephone line to call in. There's a toggle button on the right-hand side of your webinar dashboard that allows you to make that choice. Also, if that dashboard is either in your way or disappears on you, there's a small red arrow on top that lets you hide and unhide that panel. Now, even though we don't have a large number of attendees, everyone on the call is muted for the duration of the webinar, just so that there's not much background noise and we can hear the presentation clearly. If you do have any questions, problems, or concerns, please use the chat or question box that shows up on your GoToWebinar screen on the right-hand side of your computer display and type in and send your questions to me. I will forward those to Will, and we will either answer them right on the spot, or we will hold the questions to the end, depending on where it might fit in best. At the end of the session, I will also take everybody off of mute so we can have a bit of interaction and discussion and answer any questions that might not have been answered during the presentation. If you are in an area with a lot of background noise and you're calling in from your phone, for example, you can self-elect to remain muted and only open your line if you want to interact. And with that, I think we covered the basics, so I hope you'll enjoy the webinar and we'll be able to utilize the information. So let's jump right in.
Fantastic. Thank you so much, Simone. I really appreciate the opportunity that Community Capital has given me to speak with some of your clients. It looks like you have a wonderful group of clients on the phone today who are engaged in a whole variety of different and very interesting businesses in New York. I want to congratulate each of you for doing what so many of us wish we would do, which is to have the courage to stake a claim and try to add value in the world and do great things. And so for your business endeavors, I congratulate you, and I admire you. I also want to congratulate you for spending an hour or so on a beautiful June sunny day talking about law. Legal matters are not typically the things that people want to talk about in the summertime or really any time, but obviously you think it's important enough, and you think that your business is important enough to you to take this time. So I'm glad to be with you, and we'll try to make this as interesting as possible. As Simone indicated, please do not hesitate at all to submit any questions at any time. We'll try to answer your questions either in real time, or if more appropriate, we might answer some of the questions a little bit at the end. So with that, and also let us know if for any reason you can't hear me well enough. I'm happy to try to adjust the microphone if necessary. The first slide is just some legal disclaimers, but it's important. This webinar is really for educational purposes only. It's not legal advice, obviously. The transmission of this information, doesn't create a lawyer-client relationship, and you should not act on this information without talking about your specific circumstances with professional counsel. I am not an employee or agent of Community Capital, and Community Capital has no responsibility for the contents of the webinar. Okay, with that housekeeping behind us, we'll start with common mistake number one, is the failure to establish a separate legal entity. Why is it important? There are a variety of reasons why you should consider establishing a legal entity if you haven't done so, but most importantly, it shields your personal assets from your business liabilities. If you do not create an LLC or a corporation, you will essentially be a sole proprietor or a partnership. And any claims, litigation, or losses that are suffered by your business will essentially be your own losses and claims against you and your personal property. Your personal property being your home, your car, your savings for retirement, savings you may have for your kids' college. So all of those things can be in jeopardy if you do not take the time to create a separate legal entity. Looking at the list, it looks like many of you have already done that. So to some degree, maybe we're preaching to the converted, but it's worth thinking about the implication of actually creating a separate legal entity. On slide number 5 there, you'll see some of the items that you can protect against. Damages and injuries caused by your business. You can be liable for actions taken by others, right? So including people, other owners of the business, other employees, other folks who may be agents of your business. Their actions, their negligence, their bad acts will be liabilities of the company. And if you don't have a separate legal entity, then there will be liabilities of your own personal liabilities. To the extent you engage with vendors, if you are, I see we have a restaurant on the list, so you might have a vendor who might deliver to you fish or some other sort of expensive product, and over time you might accrue an accounts payable. That accounts payable will be the liability of the company. If you have not created a separate legal entity, in the event that that vendor ultimately decides to sue the company, then of course that liability will be your own liability. Liability and shielding your personal assets is very important. Now, of course, if you are involved in a litigation and you lose in a litigation and the assets and the losses exceed the cash and the assets in your company, then, as I mentioned, your personal assets could be at risk. If you create an LLC or a corporation, then you will only lose the amounts up until the investment in your company. So if you spent a number of years building your company, investing in your company, and if you had a terrible litigation that causes losses, then you will be you can lose your company. You can lose the entire investment, and of course that would be terrible. But you would not suffer losses to your personal assets. We talked about the different types of separate legal entities. For the most part, the smaller side businesses will be focused on LLCs or S corps, and I'm sure you all know the various types of documents you need to form those entities and the filings that are required. That's the easy part. And there are some tax implications that could be different for different circumstances, and so you should consult with a CPA when choosing as between an LLC or an S corp. Now, here's where it gets a little bit interesting. Mistake number 2 is the failure to maintain the separation between you and your S corp or your LLC. Why is that important? Well, an LLC or a corporation will not protect you and will not protect your personal assets if you do not respect the corporate formalities, right? So the whole idea is the courts and sort of the public at large should recognize that there's you and separately there's a legal entity. If you don't actually treat the separate legal entity as separate, then the courts will not respect the fact that you created that separate legal entity, right? So what are some of the things you have to do? Some of these are common sense, but some of them may not be. You have to keep your personal finances separate from your business finances. That means you should have separate bank accounts. You should draw up separate financial statements. You should not commingle the funds between your one company and your personal assets. The extreme example would be a person who essentially deposits every dollar made by the company into their own personal bank account, and the company never has really any money in it. That would be the extreme example, and obviously wouldn't work. You have to maintain adequate capital in your company, and you also have to maintain proper insurance. So, for instance, if someone were to sue you as a result of an accident that occurred in your company, or in the case of the vendor who sells you the fish for your restaurant, if there's nothing in your company, nothing at all, if you basically have taken all the capital out of your company as you earned your revenue, then there's really no company to speak of. The company doesn't really exist, because all it is, it's just another pocket in your. You're just taking everything from one pocket and putting the other. You do have to respect that it's a separate entity. You should limit the use of your business assets for personal purposes. When you create an LLC or a corporation, you have to create certain agreements, bylaws or an operating agreement, and you have to hold entities or corporate meetings. You have to elect officers. These officers will be you, right? So a person who has a corporation may be the shareholder, the director, and the CEO. But in each of those capacities, you will have to act different in those capacities. And that's where we say you have to observe the titles. You have to wear those different corporate hats. You have to sign contracts in the name of the company and not in your own name. The problem, again, is if you don't do these things, then if you were involved in a litigation, a court would simply look through the entity and basically go after your own assets. They just would. If you don't respect the separate nature of your legal entity, then the courts won't either. Mistake number 3, failure to adopt partners or owners agreement. when you kick off and launch a business, you're so busy conceiving of an idea, of a product. You are so busy trying to raise money for it, get attention and market your business. You're working so hard, and often there'll be someone, it could be your husband or wife, it could be other family members, it could be a neighbor, it could be a friend, it could be an old school buddy. But there are people who often will become co-venturers with you, a person who will be a co-owner in your business. It is always clear at that time that nothing wrong will ever happen. You're going to make a lot of money. You're going to sell a lot of product. Everyone will be happy. And unfortunately, it doesn't always work out that way. And so if you are going into business with another person, and so there'll be more, there'll be another person who will be a co-owner, or even if there's another person who, in your mind, will not be an owner, but will be a key manager in the business, it does make some sense to draft and prepare basically a prenuptial agreement, an agreement that clarifies a bunch of things today and makes it crystal clear what our expectations are today, so that tomorrow, if things get fuzzy and there could be disagreements about what we all intended, at least you'll have this agreement to go back to. So some of the things that the agreements, should cover is, what's the role of each person in the business? Will everybody work in the business, or will only some of us work in the business? Who will make decisions? Very often, the person who comes up with an idea, or the person who might have a little bit more of the money to put in, or the person who thinks that they're going to spend more time in the business, there's always a reason why you might think that you're going to have more say in the business. Well, if you talk to your partner, you might find that they may not agree. So how will decisions be made? Think about it and write it down. What happens if the business requires additional capital in the future? Do you each have an obligation to inject more money into the business? Is your obligation to inject more money an equal obligation? Or should someone be responsible for putting more money in? So for instance, if in the beginning you put in more money, you might think that in the future you don't have an obligation to put as much as your partner. But that may not be what your partner thinks. And it also may not be what the law of partnerships or the LLC law might say. Will you distribute profits as you earn revenue, or will you just reinvest the earnings back into the business? Do you disagree about that point or not? If there are profits, what are the percentages? Who gets to share them? A very important item is sometimes one of the partners might think that they can open up another business or invest in or support another similar business in a nearby area. You might think that that's obviously not part of the deal. But if you don't talk about it and clarify it, you're going to have potentially differing expectations. Of course, bad things happen when one of the partners thinks that the other is not carrying their load. They're not putting in the same effort. They're not, adding as much value. They're not, contributing cash or whatever. But they're not, for whatever reason, fulfilling their side. Well, what do? That's basically a business divorce. Business divorces can be extremely ugly, and it's very helpful if you had an agreement that lays out exactly how you're going to do it. In many cases, a business divorce will basically allow the partners to get a valuation, an independent valuation of the business, and basically cut up the business in such a way to reflect what their shares are. But how do you know what your share in the business is? Is your share in the business 50%, or is it 35%? If you didn't have an agreement like this, you'll just litigate this, and of course that can cost you potentially more money than your share in the business could be worth. And of course, if one owner wants to exit the business, it could create problems. If that participant is a key employee or adds a certain key value to the business, you may not want them to exit. And again, that could be a pretty messy divorce scenario. Okay, mistake number 4, verbal or handshake agreements. This is somewhat related to getting a partnership agreement in writing, but there are other agreements that you should also get in writing, particularly if you have key vendors, key customers, or even the form of agreement that you will use for all of your vendors or all of your customers. There's the expectations of when you're going to deliver your product, when you're going to, the manner in which you're going to deliver your service, the time frame around it, whether or not you should expend cost in delivering those services, whether you're allowed to engage with third parties to deliver your services. A whole lot of terms can go into the way you might deliver the work that you deliver. And your vendors and your customers need to be crystal clear on what that is. Now, in truth, many agreements with customers and vendors, they really go unwritten. But it's for you to think about whether or not you have a situation that could be unique enough or pose enough of a risk if something goes wrong that you would want to ensure that it's documented. Relationships do go bad, and conditions can change. If you indicated that you were going to deliver your product within a certain time frame, you might have assumed that it was, that weather conditions might be a certain way. But if bad weather conditions or the price of one of the ingredients in your product goes way up, you may have to change your price. Well, how do you address that? Sometimes a written agreement can help. The other important thing is memories also can fade. If you enter into an arrangement, an oral arrangement, a handshake with someone about what you're going to do, even if we all did everything that we thought we were going to do and we do it just right, if the agreement is an agreement that takes place over, a number of months or a number of years, it's possible that you might just simply have a good faith disagreement about what you agreed to. You could still have a great relationship and still just have a different memory as to what you agreed to. That could ruin a relationship. And certainly some of your relationships are probably more key than others. And so not only for legal reasons is it a good idea to have some written record of what you agree to do, but also it helps to ensure that just good faith mistakes don't threaten relationships. It is very difficult and very expensive to enforce an agreement that is not in writing. Very, very difficult. And so if someone was, supposed to provide something to you under certain circumstances and they don't do it and you don't have it in writing, and if it's big, if it's, a $10,000 contract and you're owed $10,000, that might be the sort of thing that you will have to go to court for. And in whether it's small claims court or even civil court, if you don't have a writing, then it's really one person's word against the other. It just really doesn't end well for anyone under those circumstances. You end up very often with a court or an arbitrator just sort of kind of splitting the difference because neither of you took the time to to document your agreement. Some agreements are actually not enforceable if they're not in writing. So, for instance, if you're selling a product for something over $500, the purchaser could potentially argue that there is no agreement and that it's unenforceable, and they don't owe you the money because you didn't get it in writing. Now, of course, if you delivered the services, you have a different argument, but you still don't want an agreement. You still don't want a sale to go away and have somebody say, "Well, no, actually the sale's not valid because you didn't document it." So, anytime you're selling anything for goods for over $500, you should get it in writing. And if you're performing services that will take longer than 12 months to complete, you should get that in writing as well. Mistake number 5, failure to protect your intellectual property. So there are various types of intellectual property, and some businesses have more intellectual property than others. Most businesses will have a name and a logo, and so at the very least you want to protect that, and that would be either if you're selling goods, it would be called a trademark. If you're selling services, then that would be called a service mark. These protections, they protect what's called your brand, and your brand is made up of words, phrases, symbols, colors, things that identify your business as distinctly your business and different from businesses that are like it. Trademarks and service mark rights are actually acquired by using them. So if I were to create Will's Burger Shop, just by using that name and creating a logo around it, I technically have created a trademark, but it is protected under the common law. But you receive added protection if you register it as well. Now, if I were to create Will's Burgers in Westchester, and there is another person who's selling Will's Burgers in Westchester, then I will not have created a right in my trademark. So I would not have a right in my trademark. So it's very important for you to confirm if you're thinking about creating a new name for your company or changing its name. Before you do so, you want to confirm that the name and the logo are not currently in use by someone else in your general distribution area, because you could spend a lot of money, creating this logo and selling products under that, which could be ultimately wasted, and more importantly, you could be liable to the person who has the existing trademark for an infringement claim. And under an infringement claim, they could seek to receive from you a certain portion of the profits that you might have made using a logo that in fact they had a trademark for and you did not. So very important to confirm that. There are you can confirm by running internet Google searches, which will get you a good part of the way there in terms of comfort that no one else is using it. But you'll want to also check the trademark office registers, and there are attorneys who can help you run certain searches that are not available to. They pay for these services and they have access to these databases, so the search could be a little bit more complete. So depending on how unique your name is and how much money you think you're going to ultimately spend in your business, it may make sense to engage with a trademark lawyer for that. There's another category of There's another category of intellectual property that a lot of people don't really think about, but it is very, very important because it could be very useful to you, and that is trade secrets. Think of Coca-Cola. Coca-Cola has a soda formula, and it's not really an invention, and the formula itself is not a name or a logo, but it falls within this category of trade secret. It's a trade secret because it's confidential. No one really knows what that formula is. There's all kinds of theories about where the formula is stored. And it is information that gives the business a competitive advantage, a very important competitive advantage. So you have to have both of those prongs. It has to be confidential, and you have to have a business advantage over your competitors. But it's not only Coca-Cola formulas, it's also things like customer lists or survey results or other confidential information that you may have about your business or about your clients, or maybe even about your vendors. If that information gives you a competitive advantage over your over other businesses in your market, if they were to obtain that information, if you were to suffer competitively, then you might view that as a trade secret. Now, the key to a trade secret, you don't register trade secrets. Instead, your obligation is to take reasonable steps to keep the secret a secret. You have to sign confidentiality agreements with your employees, your customers, your vendors, and anybody else who might somehow potentially have access or gain access to the information. You want to share that information only on a need-to-know basis. So guard it very, very vigorously, and you want to, institute little security measures, to have the information, stored and locked away. I see there's a question, a couple questions come in, which I'll address right now. They're on the topic of trademarks and logos. Do you need an attorney to protect your rights and trademarks and logos? You could do you could file for a trademark application on your own. You could search trademarks on your own, so you don't need it. And depending on your circumstance, if you're, if we all sort of, when we start a business, all think that it's going to be big one day, right? And so on that basis, it's always wise to engage with an attorney who can help you figure out whether or not the trademark is already being used and help you register it. When I get to the end of the slides, I'll have a slide on how to work with attorneys, and maybe we could talk a little bit about some ways to engage with lawyers in a way that can be most cost effective for you. But again, I think if if what you're doing is, if you don't think your name is really that valuable, if your thought was that, if someone else actually owned this name, I can easily just change it tomorrow, it won't be a big problem, then I wouldn't worry so much about trademarking your name or your logo. But if you have a unique invention, for instance, then at that point, trademarking your name and other phrases could be very valuable. I think there was a related question here. How do you confirm? I think we talked a little. How do you confirm whether a trademark exists? I think we talked a little bit about that, but there isn't a particular website. There would be sort of a general search of the website, and then there are databases that trademark lawyers have access to, because they pay the fees to be able to access those databases. they could help with that. There's another related question. These are great questions. Please keep them coming. This is very helpful. What's the definition of service area? Service area is going to be different in every case. So, if you operate a nail salon, well, your service area is probably going to be, pretty small. Whereas if you operate maybe a hardware store, it could be a little bit bigger. If you are manufacturing, or if you have an interesting sort of food, sort of exotic food business that's unique, and your service area could be very large. And so a large service area could be great because if you obtain trademark protection for your service area, then of course you have the right over a larger area. But it also means that before you enter that space, you'll want to have a much broader search of the trademarks that are in use. So really, again, service area is really going to depend on, it's sort of a reasonable person standard. Is it reasonable for a person who wants that service to travel a certain distance for that service, or will they really go to use local services? And I think that's how it's measured. In the case of service areas, in the case of a restaurant, again, I think it depends on the kind of restaurant. And so, if the restaurant is a unique restaurant, your service area could be larger. If there are lots of restaurants like yours, then your service area is probably going to be a little bit smaller. Okay. There are other types of intellectual property. Of course, there are patents, which relate to inventions, and there are copyrights, which relate to works of art, things like music or poems or books. Those areas are more highly specialized, and the lawyers who counsel in those areas have greater expertise, and in those cases you really are. It's very hard for you to, and not advisable to try to do that on your own. I think if you've written a song and you think it's valuable, or you've invented something, you want to talk to attorneys, pretty quickly, so that you can protect, what you have, and before someone else, finds it or replicates it. And the last bullet point there I mentioned earlier, which is it's not only about protecting your rights to property, but it's also making sure that the actions of your business do not infringe on the rights of others who own intellectual property, right? So if you design an interesting, if you invent a new technology, it's certainly one thing to want to protect that invention so that you can profit from it, but the flip side of the coin is if someone else has already done that, and if you go out without knowing that someone has already invented it, and you produce it and you sell it, then without knowing it, you'd be infringing on somebody else's intellectual property. So intellectual property is sort of a two-way street. Okay, mistake number 6, confusing independent contractors and employees. The key to independent contractors and employees is an employer or a business owner will very often prefer to hire independent contractors. And the reason is, as many of you already are aware, if you hire an employee, you have all sorts of obligations to the employee and also to the government. things that are listed on this slide. And, you have to withhold income taxes and pay FICA, unemployment taxes. You might have to provide, you have to provide workers' compensation insurance. You might have to, depending on the size of your business, provide health care. And in addition, a person who is categorized as an employee has certain rights under the federal anti-discrimination laws. And you could find yourself on the wrong side of a discrimination complaint based on, alleged harassment based on race or sex, or national origin, pregnancy, a host of other items. And of course, these laws are all very good laws, and they're in place for a good reason, and none of us want to, violate those laws. But it's important to know that with employees comes always the possibility that there could be a misunderstanding at work, and someone could think that you've harassed them on the basis of one of those statuses, and then you have a potential litigation on your hands. So, independent contractor, not the case. Independent contractors, unlike employees, independent contractors are in business for themselves. They're just like you. They're business owners, and they offer their services generally to the public. They're not, you don't supervise. That's the sort of core to the difference between an independent contractor and an employee is how much you supervise them and whether or not the person, the worker, has the flexibility to work for other people. So if you get it wrong, the consequences could be serious. So if you thought you had an independent contractor, but in fact the relationship that you shared with that worker was really an employee-employer relationship based on a whole variety of things, which we can talk about, then you may have to pay back taxes with interest, and there could be penalties. And all of these things could be very, very, very serious and detrimental to your business because the amounts could be very large, especially if the person you thought was an independent contractor was working with you for 5 years or so, or longer. All of these will add up very, very quickly. How do you know if a person, how do you know if your relationship is with a worker is an employee-employer relationship or an independent contractor? Again, the key is sort of two main things to think about. One is how closely are you supervising the worker, and does the worker have the ability to work for others? So your normal employee relationship, you're the boss. And an employee, if they want to do something in a different way than you'd like them to do it, well, because you're the boss, you're the employer, you can tell them how to do what needs to be done. When you hire an independent contractor, it doesn't quite work that way. An independent contractor brings a skill set. They bring their own tools to the job. They bring their own experience. And you hire an independent, the whole idea is they're independent. They know what they're doing. And so an independent contractor will come in, go to work, you don't supervise that person generally, and the work gets done. And if it's not the way you like it, it's not really, you obviously could say you want things a certain way. You can essentially, your contract with the independent contractor can be, I want this result. And you will ask for a result, but you don't really tell them how to get to that result. That's sort of the difference. And also, an independent contractor will have a cell phone and will be receiving calls from other potential businesses to do more work. And they'll receive those calls while they're doing work with you. Not an employee. If an employee receives a call from someone else who wants to hire them, that's a problem. That's very different. So employees and independent contractors are very, very different. One thing I wanted to note, the last bullet there, you'll see relates to unskilled workers or casual workers. Again, you run through the test in each case. There's no one factor will determine it. But very often, or most often, unskilled workers will fall in the category of employees. And that's because usually the less skilled a person is, the more you will probably have to supervise them. So be careful if you have someone on your team who you're supervising pretty directly on how to do their job. You may in fact have an independent contractor. I see we have some more questions here. Would I be considered an independent contractor of my PLLC, or am I an employee? Interesting. Well, you are not an independent contractor because, so for your PLLC, so if you created so you are the owner, you created a separate legal entity like we talked about in one of the earlier slides. You should be the member of the PLLC. You should be the manager of the PLLC. And so the member is basically the owner. The manager is like the director or the sort of the boss. So no, you would not be considered an independent contractor for your own PLLC. For tax purposes, you are an employee, and so LLCs. Again, some of the tax aspects go a little bit beyond my capabilities, but PLLCs typically will have to pay sort of that employee tax, so technically you would be, for tax purposes, an employee, but for purposes of independent contractor versus employee analysis, you would not be an employee. Okay, great question. Okay, next slide. I'm looking at the time. It is 12:51, so we have about 9 minutes. Let me try to get through the last few slides here quickly so we can leave a little bit of extra time here. Mistake number 7, hiring a lawyer to sue before attempting to resolve things out of court. The main thing on this slide is, litigation is just never a good thing. If you're headed towards litigation, I think you've already lost, for the most part, because it's going to cost you a lot of money, particularly businesses on the smaller side. It can bankrupt you, and if not, it can certainly take you away. It can distract you from the day-to-day, the important day-to-day work that you need to do to keep your business profitable. It could have an impact on your reputation and your relationships if you're constantly suing people. So you want to be careful about that. One tip for you is your contracts, to the extent they're written contracts, you might want to include a mediation or binding arbitration provision. What that does is it requires the both parties to the contract it prohibits you from going to court if there's a dispute. Instead, you have to go to a mediator, which is basically like kind of like a peacemaker, like kind of a referee who really more than a referee, someone who helps you to try to craft a solution. And if in the course of mediation you can enter into a settlement agreement, then that agreement will be binding, just as if you went to court. So it'll be a legally binding resolution to your dispute. If mediation doesn't work, and sometimes it doesn't, then these provisions would, instead of letting you go to court, where it's very costly and could take a long, long time, you instead go into a binding arbitration. So an arbiter is a lot like a judge, but much quicker. Still costs you money and the mediation costs you money too. But an arbitrator moves a lot faster. You probably will have lawyers involved if you're going into arbitration, maybe even a mediation, but less so. But anyway, if you put these into your contracts, you could avoid going into court. The problem going into court is it could take months and months and months to finish through a legal procedure. And when you hire a lawyer, and that lawyer is working with you for months and months and months, the legal bill can get very big, and so it's very helpful. Last bullet here: never bluff about suing somebody. It's you gotta be very careful in lawsuits. Well, first off, your reputation can be damaged if you're constantly bluffing. But in litigation, sometimes a person who you sue or who thinks you're going to sue them might go ahead and sue you first. So there are things called counterclaims. So the point is, if you really don't have an intention to go to court, you do not have an intention to go to court, and you act as if you do, you might find yourself in court involuntarily under those circumstances. Common mistake number 8, failure to obtain business licenses and permits. I think this is a pretty simple slide here. I'll let you guys read this on your own, given the time that we've gone through here. But the main thing is, it's one of those things, right? I mean, I think sometimes you might think you can operate your business for a little while under the radar because you're so busy, you got too much to do, and you're not really hurting anybody, and you have every intention of doing it, fine. But you really could, you can get wiped out with fines and penalties at an early stage if you don't attend to some of these little formalities. Mistake number 9, maintaining business records. Very important. You really can't, if you take the advice and put some of your key contracts in writing, and then you lose that contract, well, then that contract is basically an oral contract. It's useless. If you have an LLC or a corporation, and you do not maintain your corporate records, the minutes of your meetings, the minutes of decisions that are made, record of elections, all these sorts of things that regular corporations do. I mean, the big corporations all do this. Even if you're an S corp or an LLC and you're just a few people running a small business, you still have to maintain all of those formalities. And if you don't, you could lose that liability shield that we talked about before. And also, if you don't have records of the way you've conducted your business, your employment records, your tax records, your contracts, and other things, and if you are in a litigation, you're going to have one hand tied behind your back because you're not going to be able to produce evidence that could be very, very important in defending your case against a lawsuit. Mistake number 10, not obtaining legal advice for very important decisions and transactions. Everybody knows that the smaller businesses, earlier startups, early in your life cycle, you're making choices between surviving day by day and doing something that might look like a luxury, like calling a lawyer. And absolutely understand that, and it's really a judgment call. It's a struggle, something you have to sort of balance each time. And so, talking with, if you have a CPA, a good CPA, can help you sort of think through when you need to call a lawyer because they have lots of experience. They've seen a lot of stuff before. Community Capital, in my conversations with Kim Jacobs and others here, Juliet and Simone and others, Jesus, I've learned that that Community Capital is a tremendous, tremendous resource. They act in many ways for you. Obviously, they can't give you legal advice, but they are a good resource for you in terms of trying to figure out whether or not it's time for you to engage with a lawyer. You got to be careful with just pulling up a form off the internet because it could be incomplete or inapplicable. A form that doesn't include an important provision could be a really bad form for you. It could be perfectly fine for one business, but not good for another business. The cases where you really, really need to engage with a lawyer, is we talked about prenup agreements with co-owners or partners. It's really good to get counseling from a lawyer when you're doing that. If you're negotiating, as we talked about before, key contracts with customers, suppliers, even lenders, you may not be able to negotiate with a lender as strongly as you'd like to, but at least understanding what you're signing up to. So it's good to have a lawyer by your side when you're doing that, because very often you might even pledge your personal collateral, your personal property, and so that's a life event. I mean, you cannot do that lightly. If you're engaging with investors and talking to them, anyone who wants to put money into your business, and you're going to give them equity or something else, talk with a lawyer about what your rights should be. Obviously, if you get sued, if you are being investigated or there's a complaint against you for violation of law, if you're going to buy or sell a business, your business, another business, or assets, these are all just some of the cases where really at that point the stakes are just too big for you not to engage with a lawyer. So you got to really weigh, the risk of not having a lawyer with the risk of using one. We received a question about when you sign a lease. I think leases tend to be pretty standard and boilerplate. The trouble with that is if you might, so sometimes leases will show red lines, and basically they'll show where it changes from the boilerplate. If you have a lease that basically shows you this is how the boilerplate changed and there's not many changes, potentially you might be able to get comfortable with it. My sense is a lease could be one of the most important contracts that you might sign up to early on. So, for instance, if you're, I know there are lots of restaurants in the community capital community, and I've heard instances where restaurateurs might be very anxious to sign up a lease for a location, a property that they think is just perfect for their restaurant. But of course, if they want to get a liquor license, you end up with a chicken and egg scenario where, the landlord is pressuring you to sign your lease, otherwise they're going to give it to somebody else, but at the same time you haven't obtained your liquor license yet. And so you really should, in a circumstance like that, have a provision in your lease that says that your lease terminates if within a certain period of time you are not able to obtain the liquor license. Most landlords will understand that that is a completely reasonable provision to have in a lease where the tenant will be a restaurant. But if you don't know about that, you won't put it in. Or if the landlord pushes back on that, sometimes it's helpful to have a lawyer help you negotiate that. So I think a lease is also another good, I appreciate that question, because a lease is also another important instance where having a lawyer who's familiar with real estate could be very, very helpful to you, because you could get locked into a lease for a long period of time, and the price scale, for the lease could be unfavorable to you. Market conditions go down, et cetera. So you want to be able to have provisions in a lease that are going to be helpful to you. All right, so I told you why you should get a lawyer, but we recognize that, it's very expensive. So you want to find some ways to reduce legal expenses. First off, you don't need lawyers for everything you do, but when you determine, either based on some of the things I've mentioned above, or you're talking to trusted advisors like Community Capital or your CPA, maybe your private wealth manager, you may have somebody who gives you some guidance and advice. If you've determined that you need to talk to a lawyer, then some advice I have for you is on this last slide, which you can reduce your legal costs by, consulting with an attorney really early, before too many things happen and sort of the train leaves the station. You can really avoid a circumstance getting worse by speaking with a lawyer as quickly as possible, who can try to help you mitigate and stop the bleeding as quickly as possible. Before you go for your initial consultation, have all of your documents with you. Maybe write down, if it's appropriate, write down a chronology. Write down like all the dates of when certain, when important things happened that are relevant to what you want to talk to the attorney about. Bring all of that stuff with you. Think about, spend some time thinking about what you're going to talk to the lawyer about. Try to get to the point as quickly as possible. If the lawyer has to sort of figure out what the problem is, and there'll always be some of that, obviously. I mean, if you're not an attorney, then the attorney is going to help you with some of this. But to the extent that you can come as prepared as possible, you're going to spend less time and move the attorney in the direction of trying to solve your problem as quickly as possible, and that's going to make things cheaper. Well, the second bullet here is do some of the legwork yourself. So if you do hire the lawyer, then you should try to set up an arrangement where, if, let's say you have to go to court and get copies, maybe you can do that instead of having the lawyer do that. That could be very expensive because the lawyer's time or their associates or the paralegal's time is going to cost you money. So anything that you can do, maybe there might be some research that has to be done. It may not be legal research, but maybe you have to look into something. Anything that you could possibly do, because if you're a business person, you have tremendous skills, right? You have all kinds of skills and aptitudes, and you can figure stuff out. So you'll be surprised by how much you can add, how much value you can add to your own legal matter by helping the lawyer, particularly if the lawyer is a small practitioner and doesn't have a lot of staff. That could actually be something that they would view as very helpful. And any time that you work on something and the lawyer's not working on it, you're saving money for yourself. Another important thing is do not be afraid to ask for a very clear estimate of what the fees are going to be for what you need. Or even ask for a fixed fee. So rather than say, hey, how much are you going to charge me? And the lawyer says, well, I'm going to charge you, $100 an hour or $300 an hour or whatever, $500 an hour for this. Well, it's very hard for you to even understand what that's going to cost you. You can't even budget that. And the only way to budget that is to either get a cap on the amount of hours that the lawyer will work on this, and then you can just do the math, the cap number of hours times the rate of hours, rate per hour is going to give you the maximum that you're going to pay. And I will tell you that whenever you negotiate a maximum, you're probably always going to end up paying the maximum, so be aware that has a funny way of happening. It's just human nature, right? And or a fixed fee. You might say, well, I need this work done, and they'll say, well, can you do it for this amount? Now, I will tell you, as an attorney, lawyers don't like, fixed fees, and there's good reason for it. It's not, it's very hard to know how much something's going to take, and something that could be detrimental to both sides is if the lawyer agrees to a fixed fee, a flat fee that ultimately ends up being too low. What can happen is the lawyer ends up working for a period of time basically for free. And if a lawyer is working on your matter for free and has another matter where they're going to make money on it, again, human nature has a way of having the person focus maybe a little bit more on somebody else's matter. So trying to get the cheapest rate possible and all that, be careful and make sure that the person that you're working with really is thinking through how much time it's really going to cost them. The best case scenario is always going to be for you, it's going to be a flat fixed fee that was made with understanding all the assumptions and understanding all the facts so that the lawyer has a good sense of truly how much work is going to take. If it's an unexperienced lawyer and never done the thing before, then that person may have a hard time doing that. But someone who has a little more experience, might know, well, I've done this 3 times before, and this is how long it's taken. So, okay. So again, sometimes you're not going to engage a lawyer, but there's some good information that's available. The SBA has some good tip sheets on certain topics that could be useful. SCORE website also has, some good sort of sheets on information about some stuff. This wouldn't be legal advice because it's not really tailored for your circumstance, but it's sort of general information that could help you. Local bar associations, depending on what county you're in. Here in Westchester, we have a bar association, Westchester Bar, that has some good information on its website. And you can also call the bar associations. They have legal referral services, and very often they will provide a reduced rate for smaller businesses. So smaller businesses that that might benefit from lawyers who, in some cases, might have a little bit less experience, but maybe you don't need the most experienced lawyer for certain things. Like if you need a patent, you want to get the best lawyer you can get, right? But for some other things, incorporating your business and other things, you may not need it. If it's going to a small claims court or something, someone who's less experienced, who might show up on these local bar association referral services, could be a really good help. And then looking on the internet, there's other sites like NOLO and LegalZoom and these other things. You got to use your judgment. Some of these do have some pretty good kind of summaries of things. These are all things that you could use to educate yourself, so that if you have a problem that does require an attorney, by the time you get to the attorney, you at least have identified, some issues and have an idea of what you're talking about. So that could help minimize some things. I think we're now running over a little bit. Apologies for that. Really appreciate your participation. I have one more question here. Simone, should I just read that one?
Yeah, sure. Okay.
So for a startup, what's the best option to get legal advice? At the beginning, when we're forming a company, requires different types of legal advice. Yeah, I think that question came in maybe about a few minutes ago, so I might have already touched on that. But as a startup, there are lawyers out there who focus on startups. A lot of lawyers will not work with startups because startups often don't have the money to pay. But there are lawyers who create their business plan around working with startups, because some of them really want to work with startups. They enjoy working with entrepreneurs. They're okay taking sort of limited fees because they might make money in other ways. So I think the key is to find someone who actually likes to work with startups. That's something that I might be able to help locate some lawyers. Community Capital could help locate some of those folks. And the second part of that question was at the beginning when, yeah, okay. So I think I've answered that question, Simone. So Simone, I'll hand it back to you at this time. But again, thanks everybody for listening. I hope this was interesting and added some value to your day.
Sounds good. So yes, whatever Will just said. And what I will do is I will unmute everybody right now, just so that in case there is more questions, if you have any kind of comments, you want to just chit-chat with each other for a little bit or share things, we can do that. And like I said, if you feel you're in an environment where you can actually hear your own background noise through the webinar, feel free to mute your own lines, just so it doesn't get too crazy. So here we go. Let's see if this works. All right, I'm just going to go through it. All right. Like I said, if it gets too crazy, we might just shut everybody down again. We'll see how this goes. All right, bear with me, almost there. There we go. Okay.
All right.
Fun times. So, all right, and I see some of you already self-muted yourself, so that's good. So like I said, if you have any more questions to chat, want to share your thoughts about, any and all of this, Go ahead. I have unmuted your line, so you should be able to just talk to us as long as you're connected with a computer with a microphone or the phone line itself. If you still have issues with that somehow, then just send in your questions, and we're happy to take it from there.
Hello, I have a question. Can you hear me?
Yes. Yep.
Hi. So I have a question again about independent contractors. So when I formed the LLC, on the articles of organization, you have to put like what service you're going to practice for a professional LLC. So it says occupational therapy, but I eventually want to bring on other therapists in other disciplines, speech and physical therapy. Do I have to amend my articles of organization if I bring them on as an independent contractor?
Déjame dejarlo ahí. Yo no voy a hacer ninguna pregunta. A ver, escucha, yo necesito al abogado. How are you?
Oh, Bill, hang on. Here we go. I somehow muted you.
Now I'm okay.
Okay. So tell me, what do your articles currently state?
That the service I'll be providing is occupational therapy. And in the name of the company, it's Smile a While Occupational Therapy Services, PLLC. But I would like to bring on speech and physical therapy. But can I bring them on without amending my articles of organization if I bring them on as independent contractors?
I understand now. So basically, you started out as occupational therapy, and now you want to do speech and physical therapy. Now, let me ask you, this shows my ignorance, but is speech and physical therapy, are those under the umbrella, are those subsets of occupational therapy?
No. So
Okay.
I wouldn't be able to like supervise, I guess, speech or PT, because I don't know anything about, I'm not trained in that.
Got it. Okay. So a couple of things immediately. Number one, I presume that you have some license and permits to do occupational therapy. You would need those as well for speech and physical therapy, correct?
So I am licensed as an occupational therapist. The PTs in speech, they're licensed in their disciplines as well.
Yeah, okay. Well, I think I'd have to think about it a little bit. I mean, it's possible that you could revise your charter to contemplate other types of therapy, and then have the license to provide that therapy reside with the therapist. But I know that, so for instance, I know from my experience as a lawyer, we have our own professional rules around, who can work and operate within a law firm, right? So we have licenses that apply to us. I'm not as familiar with the licenses that apply to these different types of therapy. So I'd have to look at that, and I'm happy to take a look at that and maybe come back to you on that, if that's okay with you.
That's fine.
Okay. Thanks again for your question.
Thank you.
Okay, that was good. Anybody else? Comments, thoughts, feedback, issues? Yes, no, maybe? Oh, got really quiet. Okay.
We did run a little bit long, so that's
we did, but I'm very happy that everybody stuck around. So thank you very much for that. Nobody hopped off. Way to go. Okay, I mean, I would say if, once you digest some of this information, if you do have questions down the road, definitely either reach out to me, to Julieta, to Jesus, or to Will directly. You have his email right here on the screen.
I have a question. This is not too late.
Go ahead.
Sorry. Again, with the independent contractors. So for payment-wise, so if you have an independent contractor and you have a rate, how, okay, because I saw in one of the slides it says that I can't set the rate, if I hire independent contractors, but
Yeah.
the way I would be billing for services, the county, the rate is set by the county, or the insurance company.
Yeah, yeah. Let me clarify that. That's a good point. So when it says that you don't set the rate, that's one of those factors where you try to figure out whether someone is an employee or an independent contractor. The idea there is in an employee-employer relationship, the employer has all of the leverage. The employer has, greater control and authority and basically makes decisions, right? And so the employer decides what the rate is. In an independent contractor scenario, the rate that you pay an independent contractor is mutually negotiated.
Okay.
So when you bring somebody in to do some work, you might offer them. Now, essentially that's kind of true also with an employee. When you first hire your employee, right, you say, well, I'm going to pay you this amount per hour. But after the person's been an employee, you decide whether or not you're going to give them a raise or not, right?
Right.
It's not. Whereas with an independent contractor, if they're not happy with the price, they walk.
Right. Okay. And all right. So as far as like the insurance company or the county will set that rate, but I need to take a fee or a percentage off of that rate just for the use of my facility. And then I saw another in one of the slides, like they can't use like your supplies, but if they're using my therapy equipment that I bought for the facility, I mean, does that cause any confusion as to that employee versus independent contractor scenario? If like the facility has therapeutic supplies and that therapist is coming in and treating a kid and using it, does that like muddy the waters again?
Yeah, I think those factors that I had on that slide, and there's actually even more factors. I just want to put everything up on one slide, but no single factor will determine whether or not you are an independent. The person is an independent contractor or an employee. These are sort of, you look at them in its totality. The fact that it seems to me that the fact that some of the tools of the trade are actually in your office,
Right.
that alone, right, should not determine the result, right? If the person sounds like the folks that you're hiring, they have their own separate sort of permits and education
Right.
and experience,
Yeah.
and you're probably not in the room when the person is doing their work, right? I mean, so yeah, no, I don't think the fact that you are you as an accommodation, you have some of the tools of the trade there, would by itself that shouldn't change the analysis.
Okay. Thank you.
Okay. All right, I have somebody else who just wrote in a question, and it says, how long does it take for the trademark process to be completed? Sounds like when people ask me how long a loan application takes.
Exactly. I can come back to you with, there is a, I don't have it in front of me, but there is a minimum waiting period that the trademark office will say, well, they'll hide behind. But more importantly, there is a process for searching databases, which all that could be done in a couple of days. And then there is the process for preparing your application, and then there's the process for submitting it and waiting for it to be approved. Remember that the trademark office, once they receive your application, they are going to run their own checks and see if anyone is registered and do other things. And so it doesn't take months. I mean, it takes, I would say, weeks, but and it could be even shorter. But without having in front of me the details, it's hard for me to say exactly.
Okay. All right. Anybody else? Going once. Oh, Brendan said thank you. You're welcome. Going twice. Anything? Anybody? No, not so much. All right. Well, then, like I said, thank you everybody for tuning in. Thanks for your patience since it ran over a little bit. I think it was very interesting. I think I definitely learned a bunch of stuff. So we're hoping that you can really use the information. And again, if you have any more questions, reach out to either of us, reach out to Will directly, whatever works best for you, and then we're try to see how we can get you the information that you need. Okay. So thanks everybody. Have a great day, and we will speak with everybody soon.
Take care, everybody.
Oh, one thing before I forget.
Thank you very much.
Sorry, guys. There is one thing. I think when you click out of the webinar, there will be like a survey afterwards. So we would be really appreciative if you could fill that out. Gives us some feedback on how you thought this webinar was useful to you or not. If there's anything else that you want to learn about in the future. So if you have a couple of minutes and just could fill that out for us, I would appreciate it. Okay. Now I'm really done. Thank you, everybody.
Will do. Bye-bye.
Thanks. Have a great day.
Bye-bye now. Take